L'honorable député.
The honourable member for Abitibi-Témiscamingue on debate. Thank you very much, Madam Speaker. I'm pleased to rise tonight on Bill C-15, a bill to reinforce military justice. It will provide structure for the military justice system for the Canadian Forces. I'd like to explain that military personnel have two justice systems here, the civilian system and the military system. Most of the time they will be judged by the military justice system, but for some offenses it would be the civilian system. But I don't want to get into that in this speech or in discussing this bill. Now, given the specific nature of the role of a military staff member or a soldier, the military needs some rules that are specific to the military, but even though the military justice system has specific rules, we mustn't forget that this is part of the Canadian justice system as a whole. So there has to be some concordance between the two. We have to make sure that our soldiers are treated fairly and equitably. Therefore, we have to make sure that the military justice system, even though it's different from the civilian ones, has to comply with what Canadians have come to expect and want. So the primacy of law must be respected. Military justice exists not only for the soldiers, but it also means that this is an aspect of command to make sure that the law is respected in all circumstances. The Canadian Forces are based on discipline, which is one of the pillars of the military. So military justice reflects this need for discipline, and that's why we need this justice system. But military justice is not perfect, and it needs to be updated when problems have arisen.
We also mustn't forget that the soldiers are citizens and that their role as members of our military requires a specific type of justice system. That justice system should be as close as possible to the civilian justice system. Obviously, military justice must be as close as possible to the protections set out under the Charter of Rights and Freedoms. Or rather, even if we recognize the need to have specific provisions within the military justice system and the military system, it must not take precedence over fundamental principles of justice. Military justice procedures must be efficient and effective in order to be able to resolve problems or disciplinary issues rapidly when the situation requires that be done, so that soldiers can go back to work as quickly as possible, among other things. However, quickly does not mean circumventing fundamental principles of justice and law. So I think that we owe our Canadian soldiers who are putting their lives in danger for their country and their fellow citizens a fair and just justice system. We cannot expect our soldiers to provide the dedication and discipline necessary without having a fully equitable justice system. C-15 then is, yes, a step in the right direction to reform military justice, to align it better, among other things, with the civil system. However, the bill has limitations and does not resolve some major issues such as the following: the reform of some summary trial procedures, the grievance system reform, and reform of the Military Complaints Review Committee. During the last Parliament, the equivalent bill, which was then called C-41, had been subject to reasonable and negotiated fair amendments in committee, particularly by my colleague for St. John's East. These amendments unfortunately disappeared in this new version of the bill. Yet they had been approved by the committee and by parliamentarians, and even some had been put forward by the Judge Advocate General as a compromise in order to correct the system acceptably. Thanks to the government, we must now do the work over again that had been done during the previous Parliament. The purpose of these amendments was to seek to eliminate some of the offenses set out in the list leading to a criminal record, and I will talk mainly about this issue. We have to understand that military justice includes a number of procedures. Everybody has, of course, seen parts of court-martial trials on shows, fiction shows on TV, for example, but this gives a good idea of what happens in court-martial. But we have to understand that there are also other types of trials, such as summary trials, where we authorize the chain of command. That is the military chain of command to directly judge the soldiers who are put under their responsibility without a lawyer, without jurists, without a system of evidence and solid witnesses like in a formal court. This procedure is used in a number of cases. It's used for minor offenses concerning discipline and does not require the intervention of a court, so to speak. But we also have to say that sometimes this can lead to a criminal record that the soldiers will have to bear when they go back into civilian life. I'd like to give a few more details about these minor offenses. We can talk about absent without leave. Someone who is under the influence, I can give you an example. It's the birthday of one of your colleagues on the base, and like all your colleagues, you decide to offer that person a drink. You're young. This happens too in civilian life. It's not abnormal for somebody to be offered a drink on their birthday. Unfortunately, the next day, the soldier perhaps drank too much and is absent because he's sick, or was caught intoxicated when he went back to the dormitory by one of the superior officers on a military base. This is a breach of discipline, and we ask them to have exemplary discipline given their duties. I myself was part of the Canadian Forces, and I fully understand that discipline is an integral part of our daily life there, and you adapt to it easily, then that's okay. But from time to time, such as, for example, if somebody has a birthday, as I mentioned, where you celebrate a bit too much, there can be a breach. In civilian life, this person would probably call their boss the next day to say they can't come to work. And the individual would take a taxi to get home the evening before and would go to bed. But on a military base, this behavior is subject to a summary trial. I'm not saying here that calling your boss in the morning and not going into work because you had a party is reasonable behavior. We can also be reprimanded, suspended, or even let go if this happens all too often in civilian life. That's normal. It's not acceptable behavior. However, everybody would agree that missing work for such a situation because you drank too much the day of your birthday perhaps doesn't mean that you should have a criminal record. However, in the case of a soldier, yes. This soldier, who is perhaps 19 years of age, 20, perhaps didn't understand this, didn't understand the military justice system has a summary trial, and 15 years later in civilian life, after retirement from the armed forces, will have a criminal record. And the case will be the same as other types of offenses that lead to a criminal record, which there you can understand. So it's not normal to wind up with a criminal record for these kinds of minor offenses. It's a breach of discipline, but it's really not criminal. And also, this person winds up with a criminal record without having had a real trial. That is regulated, a trial regulated by the Charter of Rights and Freedoms. It happens very quickly. So the current bill, C-15, does not take into consideration this kind of problem, which in practice can have consequences. And I think that in this kind of case, which isn't isolated, I don't have the latest statistics, but I looked at the figures presented by the annual reports by the Judge Advocate General to the Minister of National Defence and the Administration of Military Justice within the Canadian Forces, and statistical reports on summary trials. In 2009, 2010, 2,054 trials took place, nearly 95% as a summary trial. So we're talking about the vast majority of cases here which have gone through a summary trial. For the same period, 98% of summary trials concluded with where the person was found guilty. And the charges were 28%, absent without leave, 7%, intoxication. So these are things that in civilian life don't deserve a criminal record. Even if you get a slap on the wrist, it doesn't deserve a criminal record. In the previous version of the bill that had been subject to a compromise in committee during the last parliament, the section on the exemptions for the criminal record contained 27 sections in the National Defence Act. In this version, there are only 5. So, very quickly, for C41, a person who is convicted of any of the following offences or is being convicted of any of them before the coming into force of this section has not been convicted of a criminal offence. So, A. C41, an offence described in section 85, 86, 87, 89, 90, 91, 95, 96, 97, 99, 101, 101.1, 121, 21, 122, 108, 109, 103, 102, 122, 123, 126, or 129. So, as well, the offender is sentenced to a severe reprimand or reprimand, a fine not exceeding basic pay for 1 month, and a minor punishment. For C15, here when we talk about the sections, all of a sudden we have only 85, 86, 90, 97, or 129, and I think we quickly realize there's a couple of numbers missing. And in these cases, for which the offender is sentenced to a minor punishment or a fine of $500 or less, or both. So I think that we realize quickly that there are many things that unfortunately have disappeared from the bill that should have stayed in the bill, because we can remember that these sections in C41, this was subject to a consensus, and the opposition parties as well as the government party had reached an agreement. So what I want to say is that the infractions and sentences that are excluded with regard to getting a criminal record were much more extensive. So we're talking about a reprimand, a fine not exceeding basic pay for 1 month, or minor punishment. Today, these exceptions conclude only a fine of $500 or less, or a minor punishment. In most cases, we're talking about a minor punishment or a fine of $500. This is too limited. For example, in the cases mentioned by the auditor, the JAG's report in 2010, leave without permission was subject to 5 days in detention and $1,500 fine. Others were sanctioned with 30 days in detention. These cases are not subject to the exceptions set out with regard to the criminal record. And of course, there is also intoxication, also set out in the same report, which were sanctioned by a reprimand and $5,000 fine. So once again, this is not part of the exceptions set out, and so they're not broad enough, and we need to go back to the previous version that was negotiated in committee, as mentioned by my colleague from St. John's East. Of course, I am not questioning the suitability of the sentences set out by commanders. I have had the experience of discipline within the armed forces, and I recognize that this is extremely important. However, there's a major difference between discipline on a military base and having a criminal record that normally is used to make people aware of crimes. And here we're talking about people who would get a criminal record for something that is more like something stupid that they did. So I don't think that's where we want to go. I would also like to say that according to a publication by the Department of National Defense, which is a guide for accused and assisting officers, and it states summary trials are designed to provide prompt and fair justice in dealing with service offenses that are relatively minor in nature, but which have an important impact on the maintenance of military discipline and efficiency. So here we're not talking about minor offenses. We're not talking rather about criminal offenses or major offenses. No, we're talking about minor offenses with consequences on military discipline. So military discipline is something that is not what you can find in civilian life, and I think that it would be a mistake to put these breaches on the same level. For the vast majority of the cases where there is a lack or a breach of military discipline, civilians who had done the same thing would not be subject to legal consequences. So this isn't fair to impose on soldiers consequences in civilian life when the majority of facts concern solely military life. Furthermore, a summary trial means that things could be written in a criminal record when in the same trial does not include a judge who is professionally trained, or evidentiary processes, witnesses, lawyer for the defense. So this should not lead to a criminal record. This also, there should not be as severe consequences. A summary trial is simplified here for obvious reasons when we're talking about a situation of conflict. So we want discipline to be rendered quickly so that things can go back to, the people can go back to work in case they're in a theater of operation or whatever. When it comes to minor offenses, violation of the rules or discipline, when the chain of command is authorized to judge the soldier. It's quick and it's effective. The superior knows the accused. It's not entirely neutral. The person would, of course, receive training, and there's a seminar to find out how to conduct the procedure. So there's no lawyers to ensure the respect for the rights of the accused, and yet these summary trials can lead to fines of several thousands of dollars, or even 30 days of imprisonment, or even a reduction in rank, 1 month in prison without an impartial court or a properly formed judge. I think that that's more important than what we see in the bill. These procedures that we find in a civilian trial are there to ensure one thing, and that is to ensure that the fundamental rights of an individual are respected. I see already that members of the other side will say that the NDP wants to protect criminals, but I have been in the forces, and I know that breach of discipline or failure to follow the rules has nothing criminal about it. As a soldier, we have to respect discipline, but in civilian life, it shouldn't have the same consequences as we currently see. And of course, a person should be presumed innocent before being declared a criminal. This is what we call impartiality and the independence of the judiciary. So we have to have an impartial and independent system to have the confidence of the public. In the military circles, we need to know that people can be tried. Otherwise, there won't be confidence in the system. Most of the time, we need to impose significant limitations on these summary trials. The sections that had been added in C41 are no longer in C15, and as I mentioned before, this is problematic. I would like to conclude my speech in saying that having a criminal record is something that is very difficult in civilian life, and soldiers who become civilians will have to go through the Parole Board of Canada and request a pardon. They'll have to wait 5 years after their summary trial, pay fees in excess of $600, fees which are rising, and get through all the other procedures. So I think that this bill should be changed by adding the other provisions as I mentioned. Questions and comments? The Honourable Member for Davenport.
Speaker, I'd like to thank my honourable colleague excuse me, for her speech tonight, and of course she can speak with a measure of authority that many of us can't, because she's been in the forces, and she's also a young person who can understand the issues that relate to sort of minor variances from discipline in the forces. But what I wanted to ask, get my honourable colleague to address is the issue that we ask a lot of our soldiers, that are men and women in uniform, our young men and women in uniform. Many of them come from just regular working families right across Canada, big cities, small towns, rural municipalities, and they're in this situation, and we expect a lot from them. And then, as we've heard many times in this House, of veterans of our military who are faced with very tough times, and I wonder if my colleague can comment a little bit further on the detrimental effects of the use of summary trials when young people end up with these criminal records, and how they have to deal with that later on in life, and the difficulties that they could have.
The Honourable Member for Abitibi-Témiscamingue. Thank you, Madam Speaker. To respond to my honourable colleague for Davenport, I'd like to give him the example of recruits. Often we have recruits who are 16, 17 years of age who come to really start. They have a course that's a training course, and it's really intensive, and they are often very tired, exhausted, and they can make mistakes, which they don't do intentionally, of course, but which will lead to a summary trial. For example, accidental discharge of a firearm, and no one does that on purpose, but it does happen, and the person will have to go through a summary trial, and perhaps then even have a criminal record. I have already known a colleague who was extremely tired, and he just wasn't careful, and unfortunately he put the flag up upside down. He really didn't do it on purpose. However, he had a summary trial result because it was a mistake, and it was something that was unacceptable for the military, but it's simply because of exhaustion, and this offense can also lead to a criminal record. And when you're 16, 17 years of age, I think that you really don't understand the legal system, and you don't understand what's going to happen when I get out of the Canadian Forces in 20 years. So you end up exiting the Canadian Forces 15, 20 years later, and you realize that you have a criminal record because you didn't really understand what was happening.
Questions and comments? The Honourable Member for Jean Lebert.
Speaker. Often, the military is kind of its own world, and in summary trials, military officers, they're thinking of one thing. They're thinking of discipline, how to make sure that this doesn't happen in the ranks again, and that is fine for the military. But one day, those young recruits, they put in their tour, and they leave, as you're saying, with a criminal record. And that has a very strong, I would think that would have a very strong psychological effect on those young people who've given of their time to their country. Would you care to comment on that in terms of the downside, the ill effects to our young people in terms of, and the recurring effects of a young person leaving the military with a criminal record?
The Honourable Member for Abitibi-Témiscamingue. Yes. When you leave the armed forces after a certain length of time in service and you try to go back into civilian life, most people know when you apply for a job, you have to answer the question, do you have a criminal record? Most employers ask that, so you have to say yes. And the potential employer will, of course, ask you what happened, if they're even considering your file or application, because the fact that you've ticked off that box might result in it being set aside right away. So you'd have to explain why you have a criminal record, and it might be really embarrassing to have to tell the story of this stupid thing that you've done to your future employer, and particularly if this employer might be given the not a very good impression of you, of this former military person. And, you know, everyone knows that for any job nowadays, just even working at McDonald's, you're asked if you have a criminal record.
Should have gone to the government side first. The honourable member for Edmonton Centre.
Well, thank you, Madam Speaker. And I too spent some time in the military on both sides of the justice system, administering and one time receiving. And I didn't leave with a criminal record. And I've disciplined a number of people under my command in my time in the service for things that the member suggests would carry a criminal record, and none of them are carrying criminal records. She is overstating that case tremendously. Another colleague over there mentioned it's all about discipline. Well, it's not, Madam Speaker. It's about efficiency, and discipline is part of efficiency. The emphasis on efficiency, not discipline. I think my colleague said, if I heard it correctly, that she, and I may have heard it wrong, but she thinks that the summary trial system somehow takes away the constitutional rights of the person who is accused. In fact, we have Supreme Court decisions on that point out that it does not. In fact, their charter rights and freedoms are preserved under that system. And I will add that a member gets to choose whether he or undergoes summary trial or court-martial. I may have heard my colleague wrong. I'm not sure.
The honourable member for Abitibi-Témiscamingue. Thank you, Madam Speaker. What I'd like to really emphasize here is that I don't think that a summary trial breaches a person's fundamental rights, someone who's in the forces, but if it is for a minor infraction that would not result in them having a criminal record, whereas it does when they're serving, the consequences really cause a problem. Yes, that's what I think. So I think we should improve the bill to avoid that kind of situation ever occurring. Questions and comments?
Resuming questions et commentaires.
Questions and comments? The honourable member for Pierrefonds-Dollard. Thank you, Madam Speaker, and I thank my colleague for her speech. It was instructive, I believe, because I'm not as aware as my colleague of what happens with people serving with the forces, and I thought that she presented some very important nuances. I wonder if she could say what, up until now, would be the receptivity of our colleagues concerning the amendments she's proposing, and if she would have perhaps another example she could give to us of cases that she was made aware of that would be relevant for us to hear, so that we could even better understand the amendments that should be put forward. The honourable member for Abitibi-Témiscamingue. Thank you, Madam Speaker. Currently, I haven't had the opportunity to discuss with my colleagues on the government side to see what amendments they might be prepared to accept, but if I'm to go by what happened with the previous bill, C-41, everyone seemed to have agreed on those amendments that were put forward, and I would hope that we could at least reach that same point. So I think we should be able to bring it to the same conclusion as C-41. But in terms of examples, there's one thing I'd like to point out for people who don't know what a summary trial is. Just the way in which it happens is quite impressive. When you're young, you go in with 4 people who escort you to go into the commanding officer's office for the summary trial. You have to walk at 120 paces a minute. Your hat is taken. And just the fact, just the way in which you go into the commander's officer is very impressive. And if you are a young person serving in the military and you've had the misfortune to escort colleagues before something might happen to you, we know a little bit what to expect. But I'm telling you, it's very impressive, and I think anyone escorting them even is quite upset at the outset. Resuming debate.